city of Minneapolis this year added tens of millions of dollars to a fund to cover police conduct settlements. Last year, the city added $27 million to pay the family of George Floyd.
Hey everyone, welcome back. Today, we're diving into an important topic: qualified immunity for police, and what it means when Donald Trump talks about giving the police immunity from prosecution. This might sound confusing, so let's break it down in simple terms. We'll go over what qualified immunity is, how it's used, and how it sometimes leads to serious problems in our legal system. And don't forget to hit like and subscribe for more content like this. Qualified immunity, what is it? So let's start with the basics. When Trump says he wants to give police immunity, here's a spoiler. The police already have a type of legal protection called qualified immunity. In short, qualified immunity is a legal doctrine that protects government officials, like police officers, from being personally sued for actions they take on the job, unless they violated a clearly established constitutional right. In other words, as long as there's no clear legal ruling that their actions were unconstitutional, they're generally shielded from liability. How qualified immunity works. Qualified immunity can be a powerful shield for government officials, and it's been used in cases involving serious allegations, including police brutality, fatal shootings, and other forms of misconduct. If a government official, such as a police officer, is taken to court, they can claim qualified immunity, which, if granted, dismisses the case before it even reaches trial. Who does qualified immunity protect? Qualified immunity doesn't just protect police. It covers a variety of government employees, like law enforcement officers, teachers, and social workers, helping them do their jobs without constant fear of personal lawsuits. While some protections for government officials make sense, the real issue lies in how qualified immunity is sometimes applied. The problem with qualified immunity. Here's where things get complicated. To deny an official qualified immunity, courts require proof that a clearly established right was violated. But this standard can be tricky and often too strict. Some courts interpret clearly established to mean there has to be a nearly identical previous case to prove a right was violated. This makes it harder for people to hold officials accountable, even if their actions seem clearly wrong. Let's look at a couple of ways this standard can lead to problems. 1. Overemphasis on specific cases. Some courts require that a case with almost exactly the same facts has already been decided for a right to be clearly established. This can let officials get away with bad behavior simply because no one has done the exact same thing before. 2. Ignoring broader legal principles. By focusing only on past cases with identical facts, courts might miss broader principles. This can prevent justice, especially when legal rights are evolving. 3. Disregarding the reasonable official standard. Qualified immunity is supposed to protect reasonable mistakes, not shield clear misconduct. But courts sometimes overlook whether a reasonable official should have known they were breaking the law. Here's an example of qualified immunity's misuse. Imagine a police officer uses excessive force during an arrest. The general rule against excessive force is clear, but because there's no previous case with exactly the same situation, the officer might be protected by qualified immunity. This lack of accountability can cause further police misconduct and strip the victims of justice simply based on a technicality. What about Trump's proposed immunity for police? Now, Trump has suggested giving police more immunity from prosecution, but he hasn't explained exactly what he means or how it would work. This could mean more protection for police, possibly making it harder to hold officers accountable for their actions. There's also talk that he might try to bring back policies like stop and frisk. Stop and frisk was a controversial policy used in New York City until 2013. Police could stop and search people based on reasonable suspicion. From 2004 to 2012, Blacks and Latinos made up about 50% of New York's population. The New York Police Department conducted 4.4 million stops as part of their citywide policy, and over 80% of those stopped were Black and Latino individuals. It was found that the likelihood of finding a weapon on an African-American New Yorker who was stopped was only half that of white New Yorkers who were stopped. Additionally, the likelihood of finding contraband on an African-American who was stopped was 1/3 that of white New Yorkers who were stopped. Expanding immunity, like Trump suggests, could lead to similar abuses nationwide. If police are protected from prosecution no matter what, it could increase issues like racial profiling and erode trust in law enforcement. So what is our takeaway from all of this information? Qualified immunity is meant to protect government officials doing their jobs. But when courts interpret it too strictly, it can shield bad behavior. And if Trump pushes for even more immunity, it could make these problems worse. Thanks for watching. Remember, stay informed, stay active, and stay woke. Like, subscribe, and we'll see you in the next video.